some employment law issues. Three things. One, I'm going to talk about employee handbooks. I'm going to talk about independent contractors and the big push that the government has to stop that. And then I'm going to talk about how you can protect your trade secrets, particularly through the use of covenants not to compete. Let me start off with discussing employee handbooks, and I am going to let you do that for me, if you would, since I like to be ambulatory when I talk. Employment, as almost all Texas employers know, is at will. Now, what does that mean? It means you can fire somebody anytime for any reason or no reason at all, and they can quit anytime for any reason or no reason at all. Now, that may seem a rather harsh arrangement, but given that our country's history includes slavery and involuntary servitude, it is probably a pretty good advance. Most employers in the United States would like to keep it that way, employment at will. They don't want to be restricted any more than necessary in their ability to cut an employee loose. Other states than Texas have some significant restrictions on employment at will. And of course, we all know that there really isn't employment at will anymore entirely, because there's a myriad of statutes that limit an employer's right to fire people. You can't fire people because of race, sex, age, religion, national origin, because they filed a complaint with any of a number of agencies, et cetera, et cetera. But I'm talking now about common law. And in Texas, ever since 1888, in a case called East Line Railroad, employment has been at will, and there's only one exception in Texas to the common law at will thing, and that is you can't fire an employee who has refused to perform an illegal action. So if you tell them to do something illegal and they say no and you fire them for not doing it, they're protected. But one thing employers like to protect against is having an employee handbook and having that handbook, the mere fact that they have it, be construed to limit their right to fire at will. So let's go okay. Nevertheless, you ought to have them. and just a couple of real good reasons. It becomes extremely difficult to defend against an unemployment claim, or to a certain extent an EEOC charge of discrimination, if you don't have a set of rules. Because you're saying that I fired the guy because he broke the rules. Well, if you don't have a set of rules, it's going to be much more difficult. And obviously, there are a million other reasons. You want to inform your employees of their rights and expectations. You want to cover procedural things. There's a million reasons to have an employee handbook. Go ahead. But you want to avoid curtailing at-will employment. And in Texas, you generally can. The courts in Texas are very, very generous to employers. It is hard to create a contract of employment. For years, guys like me have been standing up and telling you, don't say stupid things to your employees like, hey, as long as you do a good job, you're going to have a job with us. Or we never fire anybody unless they really screw up. Because we don't want you to create contracts or commitments that are enforceable along those lines. Having said that, though, you've got to work to create a contract in Texas. There is a generalized rejection by Texas courts of the claim that employment manuals issued unilaterally by an employer can, per se, constitute written employment contracts and create specific limitations which take the cases out of the at-will doctrine. Now, there is an exception to that, where there was a secretary worked for a company that had a collective bargaining agreement. And the secretary was not in the collective bargaining unit. But the boss assured her that you will have the same rights as the union employees have under the collective bargaining agreement. Well, then when he promptly fired her because he was in a bad mood and didn't follow any of the protections and procedures listed in the collective bargaining agreement, she sued, and the court held that that declaration gave her contractual protection, and that the employer, having promised to follow the CBA, was obligated to do so. But those are very rare, and as it said, you can't take a manual and per se constitute written employment contracts. Next. We always tell you to avoid promises of lifetime employment. We avoid telling you that you should terminate only, that you will be terminated only for good cause. But here in Texas, you can promise them anything, and it doesn't matter. Yes?
You can promise, and then you say, I didn't have a promise to you.
Well, you're getting there into a question of proof. But let's say we agree. Let's say 37 people heard the statement made. What we're saying is, even then, it's going to be awfully difficult in Texas to get the courts to make the employer live up to that promise. Next. This is a quotation from a Texas Supreme Court case. General statements like those, lifetime employment, simply do not justify the conclusion that the speaker intends by them to make a binding contract of employment. For such a contract to exist, the employer must unequivocally indicate a definite intent to be bound not to terminate the employee except under clearly specified circumstances. Wow, that's pretty broad. You can promise them anything. There was an ad campaign many years ago, promise her anything but give her such and such. Well, here in Texas, you can promise her anything. Next. General comments that an employee will not be discharged as long as his work is satisfactory don't create a contract. Neither do statements that they will only be discharged for good cause or good reason when there's no agreement on what those terms encompass. Now that is strange. It's very protective for you, but it's strange because there's a vast case history on what constitutes good cause in the employment arena. Every employment lawyer knows what good cause is, but here in Texas we protect employers. Next. Without such agreement, the employee cannot expect to limit the employer's right to terminate him. An employee who has no formal agreement with his employer cannot construct one out of indefinite comments, encouragements, or assurances. Now, nevertheless, because we in the employment law game are belt and suspenders sort of guys, we want you to have disclaimers in your handbook. We want those disclaimers to say that this, employment at our company is at will, that nothing in this handbook is to be construed to create a contract of employment, and that only a written agreement signed in blood by the president can constitute a binding contract. Well, as you might expect, next slide. Okay. We still, as you might expect, we still want to protect not just the employer's right to avoid at-will employment, we also want to protect the employer's right to totally ignore his handbook. So, we have a provision of progressive discipline, right? Everybody has these. Oral warning, written warning, termination. And it's a good thing, and I want you to follow those. In fact, in an EEOC charge of discrimination, if you don't follow those, you're going to have to explain to the commission why. And especially if you don't follow them only with your black employees or only with your pregnant employees. You're going to really have to explain why you didn't follow them. But we don't want you to be locked in. Joe Blow shot a supervisor. There's an oral warning. Shot another one. There's a written warning. And by God, if he shoots a third, we're going to fire him. Obviously, we want the opportunity to vary from the handbook provisions under the appropriate circumstances. And so you need to say something like that in your handbook as well. Next slide. Of course, having said all this under the common law, the NLRB likes to stick its nose in. This is not a political observation. Well, it is in a way. We have elections in the United States of America, and elections have consequences. If you elect the Democrats, you're going to get one set of values. You elect the Republicans, you're going to get another set. And when you change, you're going to change those values. The Democratic administration currently in office is much more pro-employee than the previous Republican administration. Duh, all right? I mean, that's just the nature of our politics. And the Obama National Labor Relations Board has been particularly aggressive in looking at certain things. And one of the things they looked at is the National Labor Relations Act gives employees the right to bargain collectively, to organize and bargain collectively. And anything that by the remotest possible application can influence or chill that right or make employees think they don't have that right is prohibited by the NLRA. So, too broad an at-will disclaimer under state law can draw the attention of the board. For example, and this is one that did draw the attention, I just didn't make this up, I further agree that the at-will employment relationship cannot be amended, modified, or altered in any way. At was a bridge too far. You remember the movie? All right, a bridge too far. Why? Because doesn't that imply, says the board, that you can't have a collective bargaining agreement? It says it can't be amended in any way. So that language was just a little bit too broad. So to say that it cannot be amended except by a written contract executed by the president, that's okay, because that could be a collective bargaining agreement. But don't use language that's so categorical that it suggests to employees that they cannot join a union. Next. I'm not going to go over all of these. They're a checklist for your benefit. Couple of things I want to mention. These are just examples, and this is not exclusive. Lots of people have different provisions. One of the things, though, move to the next one. Discrimination. Nope, go back. You were there. She is so eager to have me discuss independent contractors. Okay. Notice discrimination, harassment, disrespect toward others, including sexual harassment. You absolutely have to have an EEO policy. If you don't have an EEO policy, they're going to presume that you don't really care much about equal employment opportunity, and it's going to poison your ability successfully to defend against charges of discrimination. FMLA policy, Family Medical Leave Act. How many of you have 50 employees? Probably not a huge number of you, okay? That's only relevant to covered employers, and you got to have 50 employees to be covered. But in every wage and hour audit or investigation, they look at your family policy. And if you don't have it, well, that's technically a violation. This is way beyond my opportunity to discuss at any length, though I'm going to hit on it a little bit. But internet, email, and computer usage policies, these things are absolutely essential, because you have to have the right to keep your employees from messing with the internet, from downloading child porn, or for using the internet to harass people. You have to have the right to look at what they're doing, to control what they're doing, and to hold them responsible. And a lot of times when you, as we'll see in a moment, when you are trying to monitor what employees do, you need to tell them you're going to do it so that you have eliminated any expectation they have of privacy. Okay, next slide. Social media use policy is along the same lines. Video surveillance and search consents. These are extremely important. Searches and video surveillance. Okay, go ahead. We will get back to some of that when we talk about trade secrets and privacy. All right. Texas is probably as bad or worse than any other state about calling people independent contractors. You go out to any construction site in this state and you throw a rock, and the person it hits, there's a pretty good chance that that person is not on the payroll. They're being called an independent contractor. You know, guy shows up with an old pickup truck and a tool belt, he's an independent contractor. Well, it's nice to be an independent contractor from the employer's point of view, because you don't have to pay that 7.65% matching. You don't have to pay overtime. You don't have to do a lot of things with independent contractors. But just calling someone an independent contractor doesn't make him one. And we in Texas in particular and nationally have a bad habit of calling people independent contractors who by any reasonable stretch of the imagination are actually employees. Now, this is another one of those things where elections have consequences. The current administration has made this a huge deal. The IRS and the Department of Labor are working in concert, and they have also entered into work share agreements with state employment services like the Texas Workforce Commission. So they are out to get as many people under the employment relationship umbrella as possible. Next slide. Now, who is an employee? Under the traditional common law context, it was control. That was the factor. And you read Texas cases like, you know, when the truck ran over me, was the guy the employee or an independent contractor? You're still going to see references in state law cases here to control over the details of the way the work is performed. But the federal standards are much broader than that. People who under common law would clearly be independent contractors are employees for labor and tax purposes much of the time. Next. We look beyond control to look at other factors. Go ahead. Okay, here are the factors the Department of Labor, which has the broadest definition, look at. Number one, the extent to which the work performed is an integral part of the employer's business. If in my law practice, I hire a carpenter to redo my conference room, carpentry is not what I'm in business to do. But if I hire a so-called contract attorney or contract paralegal, they're doing the sort of things that I'm in business to do. And the Department of Labor administrator, a fellow named David Weil, just put out a clarifying interpretation in which this was a huge factor. This was given particular weight. So if they're doing what you do, they're likely to be employees. So if you're running a construction company and you're doing framing carpentry and you hire a framing carpenter, that guy's going to be an employee pretty much all the time. Whether the worker's managerial skill affects his opportunity for profit and loss. Now, the greatest case in the world that illustrates this is Brock versus Mr. W. Fireworks. Let's say that in your wisdom, you decide to supplement your income by running a fireworks stand here in Texas. Well, you can only run a fireworks stand 3 weeks of the year. 2 weeks before the 4th of July, a week before New Year's. You don't know much about the business, so you go to Mr. W. Fireworks down in San Antonio, and they set you up at a fireworks stand. They give you your merchandise, but you have considerable freedom in what you can do. You can't sell other people's fireworks, but you could sell soft drinks, little American flags, gimme caps, you know, other stuff. You can operate the stand pretty much whatever hours you want. But guess what? At the end of the day, when the season is over, Mr. W will take back what you didn't sell. You had no capital at risk, and you were not an employee, or you're not an independent contractor. You were an employee. Now that seems crazy, doesn't it? But that's a Fifth Circuit case, and that's still controlling law here in the Fifth Circuit. So you got to have some skin in the game in most cases to be an independent contractor. You got to push some chips to the middle of the table. Relative investment in facilities and equipment. Now, the carpenter may have a pickup truck and a tool belt, but the construction company invested one heck of a lot more money than that, and so that's a factor. This one comes out of a Fifth Circuit case called Rice versus Circle C Investments. Circle C Investments was a topless bar, and they were arguing that the ladies invested in costumes, dance lessons, breast augmentation surgery, etc. And the court bemusedly suggested, well, okay, maybe they did invest, but it costs a lot more money to build the club and get the liquor license and buy the booze and all that stuff. So relative investment in facilities and equipment. Next, the workers' skill and initiative. That's self-explanatory. Permanency of the workers' relationship. You do not typically have to work 30 years and get a gold watch to be an employee. But the difference between employment and independent contractor is often defined by the extent of the project. So if I hire the carpenter to redo my conference room, our relationship ends when the job ends. But if you come into work every day for years and years, as long as you're happy and your company is happy, that tends toward employment. And of course, the nature and degree of control by the principal. Control is still in there. Okay, next slide. Well, let me stop there for a moment. Any questions on independent contractor? Yes, sir.
I have a client and he's in the IT business and he gets the software programming done in Ukraine. And he paid them just by check and they considered them as a contractor. Is this?
Well, if they're not working in the United States, then they're not going to be subject to U.S. law under those circumstances. So,
You can write a check
yeah.
without any issue.
If they're U.S. citizens.
Pardon me?
If they're U.S. citizens, they're not going to be subject to?
They would be subject to discrimination laws under the EEOC v. Aramco case, but they're not going to be subject to federal labor law. Yes?
So how do the big companies get away with this? And what I mean by that is, for instance, let's take real estate agents, let's take insurance agents. I've got a family member who's an insurance agent. You can get car insurance through them. They are dictated, their hours of operation of when their insurance agency has to be open, they would rather not work till 5:30, they'd rather work till 5. And they really have to sell the insurance of the name brand that is on the building, but yet they are an independent contractor.
Yeah, yeah.
So how are they getting,
How do they get away with it? It's called lobbying. And I'm being serious as a heart attack. That issue, for example, on real estate salesmen, the real estate industry put so much pressure through politicians on the IRS that they issued an opinion that those people were independent contractors. For wage and hour purposes, they said that real estate agents were outside salespeople, and so even though they were employees under the wage and hour law, they were exempt from minimum wage and overtime. Now, so you got a lady sitting in a model home in a development for 6 months selling houses where all she does is occasionally go out and show a house or an empty lot where the house is going to be, and she's an outside salesperson. The answer is very simple. They got the golden rule. They have the gold, they make the rules. I mean, it's literally a matter of lobbying. Let me move on. All right. I want to talk about now my last, another issue is privacy. I love this slide. You did a wonderful job in finding that slide. This is an example of social media. So I post "my boss sucks." I distribute it to everyone, and as a result, I'm looking for a job, right? But guess what? The National Labor Relations Board might not think so. So, all right, let's go ahead. The traditional privacy causes of action in Texas are non-consensual use of the employee's name or likeness. So if you're going to put your employee's picture on a billboard, get them to approve. Publication of private information. Hey, guess what? Old Charlie filed a health claim today talking about his sexually transmitted disease. That's a bad idea. Third, intrusion into seclusion. That is, searches of the person, property, medical exams, tests, etc. I'm not saying you can't do those things. I'm just saying that there are some procedures you got to follow. Next. Okay. When you search a person's person, their desk, their locker, their car, any of that, you have to remove from them any expectation of privacy. So, how do you do that? You tell them, we have the right to search your locker, and by golly, we're going to do it. And then you enforce it. If you see a private lock that you don't have the key to on that locker, you cut it off. In other words, you make it clear that you not only say to begin with, but throughout your operation, that we continue to exert the right to do these kinds of searches. Next. Medical records. Under the Americans, now these are developing privacy issues, new things. The ADA requires that medical information be kept in separate files, physically distinct files. So you got the employee's personnel file here, the employee's medical information file in another drawer. HIPAA, everybody invokes HIPAA like it's the most potent thing in the world. It does apply to health insurance plans, but, next slide, information you receive as an employee record is not protected by the health privacy rule. So when you give somebody FMLA and you require them to provide a health care provider certification, that's not protected by HIPAA. That can be shared with anybody in the company who has a need to know and a right to know. But if you are the third party, if you're your own plan administrator, you don't have a third party, but you run the healthcare plan, then that applies. Privacy applies. Next. Okay. Monitoring of electronic resources. Again, give notice, get consent, get an acknowledgement that they got notice and got consent. There's a law called the Electronic Communications Privacy Act that has both civil and criminal sanctions for secret monitoring or eavesdropping. Notice the secret. You tell them first, we're going to listen to your phone calls for quality control purposes, like that recording you've heard a million times. We're going to search your computer. You don't get to use a private password. Our administrator has to know the password. We have the right to do all that, and we do it, and we're going to do it. Next. What about video cameras? Interestingly, because of the way telecommunications have developed, if there's no recording, audio recording, having a camera is still subject to the Electronic Communications Privacy Act, or is not subject to the ECPA, but can still be an invasion of privacy. So again, give notice, get consent, get acknowledgement. I know you'd rather put a secret camera in to catch the thief, but you need to avoid that. Here's a couple of examples that got employers into trouble. The employer put a video camera in the women's restroom based on rumors of drug sales. Okay, maybe. But he kept it there 2 years. And my personal favorite, the Hooters franchise took secret videos of applicants changing into their uniforms. This is a bad thing. Avoid it. Okay. Is that it? All right, thank you very much. And again, I'll stick around afterwards for individual questions.